Hi everyone, I am Vian Limas from Base HM3B, and today I am going to report Chapter 3, Law on Obligations and Contracts. So our learning objectives, identify the different kinds of obligations and contracts, enumerate the ways of extinguishing an obligation, and enumerate possible application of contracts in tourism, travel, and hospitality industry. So, discussion of the law. So, it is an obligation, is a legal duty, however created a violation of which may become the basis of an action of a law. So, every obligation has four definite elements, so without which no obligation can exist to it. So, first, an active subject, also known as the obligee or creditor, who has the power to demand the prestation. Then, second, a passive subject, also known as the debtor, who is bound to perform the prestation. Third, an object or the prestation, which is an object or undertaking to give, to do, or not to do. Then fourth is the juridical or legal tie, so the vinculum which binds the contracting parties. So the juridical tie or vinculum is based on the sources of obligation arising from either the law or contract. So it is important to identify the prestation in a certain obligation. Once the prestation is identified, you can determine who the passive subject is whom the active subject can demand fulfillment of the obligation. So the following are the obligations of the passive subject. Ins first, to deliver the thing which he has obligated himself to give. Second, to take care of the thing with the proper diligence of a good father of a family. Third, to deliver all its accessories and accessors. 5. 4. To pay damages in case of breach of obligations. So, obligations to do. First, if the debtor fails to do what he is obliged to do, it will be done at his expense. Second, if the work is done in contravention of the tenor of the obligation, it will be redone at debtor's expense. Then third is, if the work is poorly done, it will be redone at debtor's expense. So, the sources of liability for damages of a party in an obligation are as follows. So, first we have fraud. So, the fraud is incidental fraud o dolo incidente, which is fraud incident to the performance of an obligation. So, in fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. So, fraud implies some kind of malice or dishonesty, and it cannot cover cases of mistakes and errors of judgment made in good health. Then second is we have negligence. So the negligence refers here in the case of contracts. Example is common career. So is culpa contractual, the lack of diligence or carelessness. So negligence consists in the omission of that diligence which is required by the nature of the obligations and corresponds with circumstances of the persons or the time at the place. So the law, Article 1157, obligations arise from first law, second contracts, third quasi-contracts, fourth acts of emission punishable by law, and last is quasi-delicts. So, discussion of the law. So, there are only two sources of obligations, namely first law and second is contracts because obligations arising from quasi-contracts, crime, so number 4 Article 1157 Civil Code of the Philippines, and the quasi-delicts are really imposed by law. So, a contract is a meeting of the needs between two persons whereby one binds himself. So, with respect to the other, to give something or to render some service. Then, quasi-contracts refers to a lawful, voluntary, and unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. So, the nature of quasi-contracts may be best described as licit and purely voluntary acts. So, two common forms of quasi-contracts are first is solutio in debiti, so which is payment by mistake, And second is negotiorum gesteo, so which takes place when a person without the consent of the owner assumes the management of an abandoned business. So, civil obligations arising from criminal offenses are governed. So, first, by the provision of the revised penal code. So, example, restitution, reparation of the damage caused, indemnification of consequential damages. Then, second is by the provision of the civil code on damages. So, example is moral, exemplary, and nominal damages. So, quasi-delect is also called culpa aquiliana. So, is any act or omission which causes damage to another. So, there being fault or negligence, and there being no pre-existing contractual relation between the parties. So, the law. Classification of obligation. So, first is primary classification of obligation under the Civil Code. So is pure and conditional obligations, Article 1179 to 1192. Then obligations with the periods, Articles 1193 to 1198. Then alternative 1199 to 1205. And facultative obligations, Article 1206. Then joint and solidary obligations, so Article 1207 to 1222. Then E is divisible and indivisible obligations, Articles 1223 to 1225. And last is obligations with the penal clause, Article 1226 to 1230. So, secondary classification of obligations under the Civil Code. So, we have unilateral and bilateral obligations, Articles 1169 to 1191. Real and personal obligations, Article 1163 and 1168. Civil and natural obligations, Articles 1423. And last is legal convention and penal obligations, so Article 1157, 1159, and 1161. Discussion of the law. So, a pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment. Then, a conditional obligation is one whose consequences are subject in one way or another to the fulfillment of the condition. Then, an obligation with a period, so it is one whose consequences are subject in one way or another to the expiration of the said period or term. Then, joint obligation are those where, although there concur two or more creditors and debtors, so in one and the same obligation, so there is no right to demand nor a duty on the part of each of the latter to render entire compliance of the entire obligation. So, modes of extinguishing obligations. So, the law, Article 1231, obligations are extinguished. So, first, by payment or performance. Second, by the loss of the thing due. Third, by the condemnation or remission of the debts. Fourth is by the confusion or merger of the rights of the creditor and debtor. Fifth, by the compensation. And sixth is by novation. So, discussion of the law. So, there are other causes of extinguishment obligation which are not expressly provided under the above provision. So, we have death extinguishes. So, obligation which are purely personal in character such as partnership and agency. Then, fortuitous events, also known as force majeure or caso fortuito, are terms which exempt an obligor from the liability. Then we have fortuitous events may be produced by two general causes. So first is by nature. So such as earthquakes, storms, floods, epidemics, tsunami, and more. Then second is by the act of man, such as armed invasion, attack by bandits, governmental prohibitions, robbery, and more. Contracts. So the law, Articles 1305, A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something to render some service. So, discussion of the law. So, first is consent, which is manifested by the meeting of the minds of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Then, offer, the must be certain and the acceptance absolute. Then, second is object certain, which is the subject matter of the contract. And third is cause of the obligation, which is established. So, a contract of adhesion. So, it is defined as one in which all the provisions have been drafted only by the one party, usually a corporation or insurance company. So, the only participation of the other party is the signing of his signature at or his adhesion. So, characteristics of a contract. So, first we have mutuality of contract. So, it means its validity and performance cannot be left to the will of only one of the contracts. Then, second is autonomy of contract. So, parties are free to stipulate the terms and provisions in a contract as long as these terms and provisions are not contrary to law, morals, goods, customs, public order, and public policy. Then, third is relatively of contract. So, contracts are binding only upon the parties and their successors in interests. Fourth is consensuality of contracts. So, contracts are perfected by mere consent and no form is prescribed by law for their validity. Then, fifth is obligatory force of contracts. So, by the obligatory force of contracts, it's constitute the law as between the parties who are compelled to perform under the threat of being sued in the court of law. So, classification of contracts. So, first is according to the relation to other contracts. So, we have preparatory. So, those which have for their object the establishment of a condition in law, which is necessary. So, example is partnership, agency, common carrier, or insurance. Then we have principal, so those which can subsist independently from the contract. So, for example, sale, lease, common carrier, and then insurance. Then we have accessories, so those which can exist only as a consequence of or in relation with another prior contract. So, for example, is pledge and mortgage. So, according to their perfection, so we have consensual, so those which are perfected by the mere agreement of the parties, example, sale and lease. Then we have real, so those which require not only the consent of the parties, but also the delivery of the object by one party to another. So, example is comodatum and deposit pledge. Then we have according to their form. So, common or informal. So, those which require no particular form. Example is loan. Then, special or formal. So, those which require some particular form. Example, donation, chattel, mortgage. So, according to their purpose. So, first is transfer of ownership. Example, sale. Then second is conveyance of use, example comodatum. Then rendition of service, example agency, list of service and labor. Then according to their subject matter, so we have things, example sale, deposit, then pledge. Then services is example is agency, list of service and labor. So according to the nature of the vinculum which they produce. So we have unilateral, so those which gave rise to an obligation. Example is comodatum, gratuitous deposit. Then bilateral, so those which gave rise to reciprocal obligations. Example is sale and lease. Then according to their cost, so we have onerous, so those in which each of the parties procure for himself. Example is sale, insurance, common carrier. Then gratuitous, so those in which one of the parties proposed. Example is comodatum. So according to the risk involved, so we have commutative, so those where each of the parties acquires equivalent. Example is lease. Then we have aleatory, so those where each of the parties has to his account. Example is insurance. Then according to their names or norms regulating them, so we have nominate. So those which have their own individuality, so example sale, lease, and common career. Then we have innominate, so those which lack individuality. So innominate contracts classified as four groups. So we have do it des, so it means I gave and give you. Then second is duot fascia, so it means I gave and you do. Then third is fasciot fascia, so it means I do and you do. And last is fasciot des, so it means I do and you do. So that's all on my report on chapter 3, Law on Obligations and Contracts. So I hope that you've learned something and thank you for listening.